Dear friends, we'll discuss today the provision of Section 83 of the Central Goods and Services Tax Act 2017, which provides for the provisional attachment of the property, including bank account of the taxpayer, in certain cases. Section 83 speaks about provisional attachment to protect revenue in certain cases. They say that where after the initiation of any proceedings, earlier under this section, there were 6 sections under which proceedings were initiated and pending. Then the Commissioner has power to attach the provisional bank account if he has reason to believe and feels that it is necessary to do so to protect the government revenue. Then he will mention this in his order of his opinion, then he can attach the bank account. Earlier there was 6 sections under which proceedings were pending. Their sections were 62, 63, 64, 67, 73 and 74. Now they have widened the scope of this section 83. Now they said that where after the initiation of proceedings under chapter 12, chapter 14, chapter 15, it covers a wide range of section 59 to 64, 67 to 72, 73 to 84. If any proceedings have been initiated under the chapter 12, chapter 14 and chapter 15, the Commissioner is of the opinion that for the purpose of protecting the interest of the government revenue, it is necessary so to do. He may, by order in writing, attach provisionally any property, including the bank account of the taxpayers, and with effect from 1st January 2021, they can attach the bank account of the person who was specified under sub clause 1A of section 122. This amendment was carried out with effect from 1st January 2021. Now, the latest judgment on this issue of Honorable Delhi High Court dated 16 May 2023 in the case of Siddhi Vinayak Camtech Private Limited, the Honorable High Court discussed the provision of Section 83 and they said the word used Commissioner under Section 83, it means necessarily refer to the Commissioner who exercise jurisdiction under the Central Goods and Services Tax Act in respect of the taxable person. The petitioner in this case was not under the jurisdiction of the Commissioner. They said the Commissioner whose territorial jurisdiction is confined by the board to a particular territory is only authorized to attach the bank account of the taxable person. Suppose there is a raid and search or seizure has taken place in respect of a taxable person who is in UP, and during the course of search inspection, the department found that he is involved in respect of certain tax invoices or evasion of tax, and that person, taxable person, is situated in Punjab or some other places, but certainly not in UP. Then the Commissioner who is in UP cannot attach the bank account of the person who is in other state of Punjab, because that Commissioner does not have the territorial jurisdiction in respect of the taxpayer person who is in Punjab. And principal condition necessary for provisionally attaching a property, including bank count under Section 83 of the Central Goods Act, is formation of an opinion by the Commissioner that such attachment is necessary for protecting the interest of the government and the revenue. It is now well settled that formation of the opinion cannot be a mere subjective satisfaction of the Commissioner empowered to take measure under Section 83 of the CGST Act, but must necessarily be an opinion which is formed on credible material having live link with formation of the opinion. The Honorable Supreme Court in the case of Radhakishan Industries set out the parameters for exercising powers under Section 83 of the CGST Act in the following words. They said, the power to order a provisional attachment of the property of the taxable person, including a bank account, is very serious and in nature, and the conditions which are prescribed by the statute for a valid exercise of the power must be strictly fulfilled. The exercise of the powers for ordering a provisional attachment must be preceded by the formation of an opinion by the Commissioner that is necessary so to do for the purpose of protecting the interest of the government revenue. Before ordering a provisional attachment, the Commissioner must form an opinion on the basis of tangible material that the assessee is likely to defeat the demand, if any, and that therefore it is necessary so to do for the purpose of protecting the interest of the government revenue. The Honorable Supreme Court observed that the formation of the opinion must be on the basis of the tangible material which has the live link of the demand likely to be recovered. The expression necessary so to do for protecting the government revenue implicates that the interest of the government revenue cannot be protected without ordering a provisional attachment. Further, Honorable Supreme Court observed the formation of an opinion by the Commissioner under subsection 1 of Section 83 must be based on tangible material bearing on necessarily of ordering a provisional attachment for purpose of protecting the interest of the government revenue. Honorable Supreme Court in the case of the Commissioner of Income Tax, Delhi versus Calibrator of India Limited said the existence of tangible material as set out by Supreme Court that reason to believe that the income has escaped assessment, which is necessary precondition for initiating proceeding of for reassessment. In this case, the department has reopened the assessment of the assessee under Section 147, and the Commissioner taken the reason to believe that income has escaped. Then Honorable Supreme Court said that what is the material available with the department on the basis of which the Commissioner forms an opinion, that should be on the basis of tangible material. That must be based on tangible material that has a live link with the formation of such belief. The formation of opinion by the Commissioner that is necessary to provisionally attach any property under Section 83 of the CGST Act must meet the objective standards as set out by the Honorable Supreme Court in Calibrator of India Limited case. The language of Section 83 of the CGST Act that says the Commissioner to form an opinion that is necessary to attach the property of taxable person. However, the said opinion is required to be based on relevant facts and not merely on the ground of suspicion. It is difficult to imagine that a company would survive if its bank account are frozen for a protected period of time. That period is for 1 year. Thus, The nature of the power make it necessary that the same must be exercised with due caution and only where it is necessary. Act should not be opinion in the air. Opinion must be on tangible material and has a live link with the facts of the circumstances of the case. Mere suspicion that is the petitioner is a dummy company which is founded on the basis of the statement that one of the director of the company or the employee, that has no meaning. Opinion should not be based on any suspicion. It must have related to the tangible material and also having a live link with the facts and circumstances of a particular case, in which case the commissioner is going to give an order for attachment of the bank account. Thank you very much.